So I'm Tom Friedland. If you look at the screen, it says Sandy Friedland, who is going to be in charge of the program once I stop talking. I'm the president of the Berkeley City Club, and I want to welcome all of you here. If you're a member of the City Club, I want to thank you for sticking with us during this pandemic time when we can't offer our usual services. For you and for those who are in Berkeley, I want to invite you to eat at Julia's on the terrace, which is open for outdoor dining, or to use our curbside pickup, which we offer Tuesday through Saturday every week. We have one of the better chefs and restaurants in Berkeley, and I hope you'll enjoy it. If you're not from Berkeley itself, I hope you'll stay at our hotel. If you're in Berkeley and want to stay for a weekend at our hotel, I hope you do that. Our hotel has been open since July 31st. And I also invite you to go to our website and sign up for our newsletter, which will keep you informed of special offers either at the restaurant or at the hotel. And with that, I will turn the microphone over to Sandy and let her take over.
Okay, welcome everyone. Throughout the evening, you may think of questions that you'd like to ask our very special guest tonight. There's a chat function at the bottom of your screens. I'm sure most of you are familiar with that. If you write a message in the chat function at the end of the formal presentation, I will then read your questions. We may have too many to cover tonight, but we'll do the best we can. Okay, as most of you probably know, the Supreme Court recently decided some momentous politically charged cases about abortion, dreamers, LGBTQ employees, presidential power, and more. Last year, Dean Erwin Chemerinsky gave us a preview of that session and predicted the outcomes of 5 of those cases. So how did he do? I'm not sure he totally remembers, but we'll find out tonight as he helps us to understand how the court ruled and the significance of those big decisions. But first, I want to make sure you know just how lucky we are to have Dean Chemerinsky with us tonight. And I hope you don't mind, Erwin, if I call you Erwin.
Please.
I don't want to trip over your last name. You have a lot of fans, and it was easy to find some great lines about you. In 2001, an LA Times reporter wrote, his friends joke that Erwin sleeps only in leap years. He juggles enough commitments to exhaust a small law firm. And with the 1995 O.J. Simpson murder trial, his recognition grew beyond academia and legal circles as his commentary became a staple on local and national television. A television news producer at the time recently recalled, I knew I could always count on a soundbite from him that would encapsulate legal analysis in a credible, understandable way. Newspapers, law journals, radio and television stations have continued to call on Erwin for quotes, opinion pieces, and insight into legal and political issues. As it turns out, the scholar did not intend to go into law. He grew up in Chicago's South Side, one of 3 children of working class parents and the first in that family to go to college. He hoped to become a high school social studies teacher, but sometime in his senior year, he decided he wanted to be a civil rights lawyer and squeaked in under the deadline for taking the LSAT for the following year's law school term. He must have done pretty well because Harvard Law School admitted him and he graduated with honors. He worked for a law firm for a few years, but still yearned for that classroom. In 1980, he was asked to teach a con law class at DePaul University Law School. And after his first class, he told his wife, this is what I want to do forever. He taught at DePaul for 3 years, then spent 21 years at USC and 4 more at Duke. He then returned to California to help found UC Irvine's law school. In 2017, he became dean and professor of Berkeley Law. And that same year, National Jurist magazine named him the most influential person in legal education in the United States. He's written 11 books, including some on constitutional law, criminal procedures, and federal jurisdiction. His most recent books are We the People, A Progressive Reading of the Constitution for the 21st Century, Closing the Courthouse Doors, How Your Constitutional Rights Became Unenforceable, and Free Speech on Campus with Howard Gillman. He often argues appellate cases, including before the Supreme Court. And I might add, he also answers emails promptly. It's my great pleasure to introduce Dean Chemerinsky.
Thank you. What a sweet introduction, and what an honor and a pleasure to get to speak tonight. It was an amazing year in the United States Supreme Court. I thought what I would do is offer a few observations about the term, then focus on 5 major cases, and then be sure and leave a lot of time for any questions that you have. My first observation is, why was this term different from all other terms? Well, to begin with, the Supreme Court decided fewer cases. The Supreme Court decided just 53 cases, signed opinions after briefing and oral arguments. That is the fewest number since 1862. In part, that's because the Supreme Court canceled oral arguments in March and April. That's the first time the Supreme Court has done that since October 1919 in the Spanish flu. The court put 10 of those canceled cases over for argument in May. In May, the Supreme Court held oral arguments by telephone. It's never done that before. The Supreme Court did live audio broadcasts of those cases. Never before has that happened. In fact, the Supreme Court has always resisted the idea of video or audio broadcasts. But this occurred. We could all participate by listening. The justices didn't finish their term until Thursday, July 9th. You have to go back 35 years to find an instance where the court took so long to hand down its decisions. Second observation, it's truly the John Roberts court. John Roberts was in the majority in 97% of all of the decisions. Roberts dissented only twice all term. When the Chief Justice is in the majority, the Chief assigns who's going to write the majority opinion. John Roberts assigned to himself writing many of the most important decisions of the term. In fact, it's stunning of a relatively small number of cases that I can discuss in a short time tonight, how many of the majority opinion written by John Roberts. When Anthony Kennedy retired, it was clear that Roberts was going to be the median justice ideologically, the justice in the middle, the swing justice. We haven't had an instance in a very long time where the Chief was the swing justice, but he sure is now. Third and final overall observation, it's a term that defies easy ideological characterization. I know that the media at the end of the term talked about the surprising liberal results, and there were a number, and I'll talk about them. On the other hand, there were also very notable conservative victories, especially with regard to the religion clauses. One statistic that I find particularly revealing for the term is that there were 14 5-4 decisions during the term. In 10 of them, 10 out of 14, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. In 2 of them, the majority was Roberts, Ginsburg, Brierson, and Kagan. There were other majorities in the other 2 cases. But notice in 10 of 14 cases, the traditional conservative-liberal split held with the conservatives being in the majority. I think what we saw this term is there's really an ideological continuum among the justices. At the far right, you've got Clarence Thomas and Samuel Alito. They voted together all the major cases this term, and in many instances, there were 7-2 with just Thomas and Alito in dissent. Then you've got Brett Kavanaugh. He was with Thomas and Alito the vast majority of instances, but not all of them. And sometimes, even though he came to the same result, he wrote a softer opinion than Thomas and Alito. Then you've got Neil Gorsuch. In some ways, he is more of an enigma than the others. He certainly is much a conservative as the ones I've just mentioned. And sometimes he's with Thomas at the far right of the court. But there were at least a couple of instances this year where Gorsuch was with the liberal justices to create the majority. And I'll be talking about that. And then right in the middle, you've got John Roberts. And then as you progress to the left, you've got Breyer and Kagan. Now, to be sure, they're left of center, But even in the cases I'll talk about tonight, there were some 7-2 decisions where they were in the majority with the conservative justices. And then the far left of the court is Justice Ginsburg and Sotomayor. They were often together in 7-2 decisions where they were in dissent. I think as lawyers approach the court next year, that as long as these are the 9 justices, it's important to take into account this spectrum, not just think of it as 2 groups, the 5 conservatives and the 4 liberals. This term was characterized by an exceptionally large number of blockbuster decisions. When I spoke before to you, I said that that was going to be the characteristic of this term, and it definitely turned out to be the case. Now, it was mentioned that I offered predictions when I was with you before. Thankfully, I don't remember my predictions, but whenever I make predictions about the Supreme Court, I invoke the memory of my late grandmother. When she was alive and she would see a pregnant woman, my grandmother would always guess the sex of the forthcoming baby. If she got it right, she'd never let you hear the end of it. And if she got it wrong, she'd never mention it again. So in that vein, I'm not going to go back to my predictions, but I will tell you what the court decided. Given the time that I have to speak and wanting to allow questions, I decided to pick 5 areas, what I regard as the 5 most important of the term, and I decided to just cover them in alphabetical order by topic. Couldn't figure out a way to order them otherwise, and alphabetical seemed a neutral principle. So the first area of case I want to talk about concerns abortion. And the case is June Medical Services versus Russo. It involves Louisiana law that says that in order for a doctor to perform an abortion, the doctor had to have admitting privilege at a hospital within 30 miles. If that sounds familiar to you, it's because just 4 years ago, the Supreme Court declared an identical Texas law unconstitutional. That case was Whole Women's Health versus Hellerstedt. And the Supreme Court in that case, in a 5-3 decision, held that the requirement was an impermissible, undue burden on a woman's right to abortion. Justice Breyer wrote the opinion there, joined by Justices Kennedy, Ginsburg, Sotomayor, and Kagan. Justice Breyer said that a requirement that a doctor have admitting privileges would not do anything to protect women's health. Rarely do women having abortions need to be hospitalized. And if they do need to go to the hospital, doctors at the hospital provide treatment. No need to have the doctor from the clinic have admitting privilege at the hospital. Justice Breyer also said that the effect of the Texas law would be to close most of the facilities in Texas where abortions were performed. Justice Alito wrote the dissent, joined by Chief Justice Roberts and Justice Thomas. Louisiana literally copied the Texas law, verbatim. A federal district court struck down the Louisiana law. The federal district court said, this is the exact same statute that the court struck down in 2016. But the United States Court of Appeals for the Fifth Circuit, in a 2-1 decision, reversed and said that there were differences in the factual record from the Texas case compared to the Louisiana case. It came to the Supreme Court. Everyone noted that no longer was Justice Kennedy, who had been the 5th vote in Whole Woman's Health, still on the bench. And John Roberts had never voted to strike down any restriction on abortion since becoming Chief Justice in October of 2005. But in a 5-4 decision, the Supreme Court reversed the Fifth Circuit and declared the Louisiana law unconstitutional. There was no majority opinion. Justice Breyer wrote for a group of 4. He was joined by Ginsburg, Sotomayor, and Kagan. And he repeated the analysis from Whole Woman's Health. He talked about how there should be deference to the fact-finding of the trial court. He said here the trial court found that this would do little to protect women's health, but it would close a number of the places where abortion is performed in the state. I think, to everyone's surprise, John Roberts was the 5th vote for the majority. He wrote just for himself. Technically, it's called concurring in the judgment, meaning he agreed to the conclusion, but not the reasoning of the other four justices in the majority. John Roberts said he dissented in Whole Woman's Health, and he believed that the majority was wrong there. He said he still believes the majority is wrong, but said he believes it's important to follow precedent. And this was a 4-year-old precedent that declared unconstitutional identical law. He said we should respect precedent, and on the basis of that, declared the Louisiana law unconstitutional. What does this mean for the future with regard to abortion? Well, abortion rights supporters would say this is a good sign. John Roberts is talking about precedent in an abortion case. Maybe it shows that when the issue comes before the court of overruling Roe versus Wade and Planned Parenthood versus Casey, John Roberts will vote to affirm them. On the other hand, those who oppose abortion rights say John Roberts' opinion was a very narrow one. It was really about overruling a 4-year-old precedent. Also, they say that though Roberts went along with the majority's result, he didn't agree to their reasoning. Justice Breyer's reasoning was that you balance the burden on abortion rights versus the benefits to women's health. And John Roberts didn't want to use that analysis. So it's hard to know really what it means for the future. States have adopted literally hundreds of restrictions on abortion, and they're making their way through the courts. Some, like Alabama's, would end all abortions. Some, like Ohio's and Iowa's, say that abortion isn't allowed after the fetal heartbeat is detected about the 6th week of pregnancy. So it effectively would end almost all abortions. What will the Supreme Court do when these issues get to the court? Well, at least Whole Women's Health, followed by June Medical Service for G, shows for now, at least as a majority, to strike down some restrictions on abortion. Continuing my alphabetical look at the term, the second area I want to talk about concerns civil rights. And the key case here is Bostock versus Clayton County, Georgia. Bostock versus Clayton County, Georgia involves one of the most important laws adopted in my lifetime, the Civil Rights Act of 1964. Title VII of that law prohibits employment discrimination on the basis of race, sex, or religion. The question in Bostock is, does the prohibition of discrimination because of sex also prohibit employment discrimination based on sexual orientation or gender identity? There were actually 3 cases before the court. 2 had been consolidated for the briefing and oral argument. It was Bostock versus Clayton County, Georgia, and Zarda versus Altitude Express. Both of them involved gay men who were fired when the employers learned of the men's sexual orientation. The other case involved, it was called Harris Funeral Homes versus Equal Employment Opportunity Commission. It involved a transgender woman, Amy Stevens. She had worked for 6 years as a funeral home director at Harris Funeral Homes. She notified the owner of the funeral homes that she was transitioning and that rather than wear the coat and tie of male employees, she would wear the skirt of female employees and also wish to be addressed as Amy Stevens. The employer said it violates my religion to employ a transgender individual. I believe sex is God-given, and fired her. She went to the Equal Employment Opportunity Commission that ruled in her favor. She went to the Harris Funeral Homes appealed to the Court of Appeals, the United States Court of Appeals for the 6th Circuit in Cincinnati. It ruled in her favor, and Harris Funeral Homes went to the Supreme Court. It's worth noting that the Trump administration came down on the side of the employers in all of these cases. The Trump administration said that it believed that Title VII did not prohibit employment discrimination based on sexual orientation or gender identity. On Monday, June 15th, in a 6-3 decision, the Supreme Court held that Title VII prohibits employment discrimination based on sexual orientation or gender identity. Justice Neil Gorsuch wrote the opinion for the court. It was joined by Chief Justice Roberts and Justice Ginsburg, Breyer, Sonoran, and Kagan. Justice Alito wrote an angry, vehement dissent. Counting the appendices, the dissent was over 100 pages long and crashed the Supreme Court's website on Monday, June 15th. Justice Kavanaugh wrote his own separate dissent. Justice Gorsuch, for the majority, said, in interpreting a statute, the court should look at the plain meaning of the language. He said, this law prohibits discrimination because of sex. To fire someone on the ground of sexual orientation or gender identity is to fire them because of sex. I think a simple hypothetical illustrates this. Imagine an employee named Chris. Chris has never met the employer in person. They just communicate by email and text. Chris is often referred to a husband and speaking about evening, weekend vacation plans. The employers always assumed that Chris was a woman. When the employer meets Chris for the first time, the employer is surprised that Chris is male. The employer says, I don't want a gay person working for me. You're fired. If Chris had been female, Chris would still have that job. But because Chris is male, Chris lost the job. That's employment discrimination because of sex. Likewise, if Amy Stevens were male, she would still have been working at the Harris Funeral Homes. Because she's female. She lost that job. That's discrimination because of sex. Justice Alito, in his dissent, said, that's not what plain meaning is at all here. He said, if we talk about firing somebody because of sex, it means something different than firing them because of sexual orientation or gender identity. He said, Congress never meant to prohibit sex orientation or gender identity discrimination in 1964. He said, this is going to cause so many pernicious effects. He said, what's this going to mean for who gets to use bathrooms and locker rooms? So what's going to mean for religious employers who don't want to employ gay, lesbian, or transgender individuals? Justice Kavanaugh also dissented, though it was milder in tone. And he said this should just be left to Congress. If Congress wants to amend Title VII through its sexual orientation discrimination, you can do so, but it shouldn't be for the court. Why does the case matter so much? Well, first, over half the states lack laws that prohibit employment discrimination based on sexual orientation or gender identity. Employees in those states had no protection from employment discrimination. Now they do. Second, there are over 100 federal statutes that prohibit sex discrimination in various contexts. Take Title IX of the Civil Rights Act that says that educational institutions that receive federal funds can't discriminate based on sex. Now that the Supreme Court has said that prohibitions of sex also forbid discrimination based on sexual orientation and gender identity, that would seem to apply to all of these statutes. In fact, just since the Supreme Court handed down this case on June 15th, 2 federal courts of appeals have already said that Title IX prohibits discrimination against transgender students, such as the access to bathrooms or locker rooms. I think the issue that is going to be much litigated after this case is what about employers who have a religious objection to employing a gay, lesbian, or transgender individual? Justice Gorsuch left this question open in his majority opinion. Justice Alito raised it in the dissent. And I worry, based on the religion cases I'll talk about in a moment, how the court might be inclined to allow such discrimination and open a huge loophole to the victory for civil rights in Bostock versus Clayton County, Georgia. Continuing alphabetically, the third case I want to talk about concerns DACA, Deferred Action for Childhood Arrivals. The case is Department of Homeland Security versus University of California. As you know, President Obama issued an executive order that created this program, Deferred Action for Childhood Arrivals. It applies to people who were brought to the United States younger than the age of 15. It applies if they're either in school or been successfully graduated, or in the military or been honorably discharged. To qualify for the program, an individual cannot have a felony conviction or a conviction for serious misdemeanor. If someone qualifies, and get so-called DACA status, it means they get deferred deportation for a 2-year period. In simple English, it means they don't have to fear being deported for 2 years, even though they're not lawfully in the United States. Also, it means they'll get certain benefits like work permits and privileges. It's estimated that as many as 800,000 individuals have gotten DACA status. Many on the Berkeley campus, some in my law school, are these so-called dreamers. President Trump announced he was rescinding DACA. The Department of Homeland Security issued an order rescinding the DACA program. A number of lawsuits were filed around the country. I was co-counsel in a lawsuit filed by public counsel on behalf of DACA recipients. The University of California filed a lawsuit. Lawsuits were filed on the East Coast. The federal district court in the Northern District of California found President Trump's rescission violated a federal statute, the Administrative Procedures Act. The Ninth Circuit affirmed. Likewise, 2 federal district courts on the East Coast, one in New York and one in Washington, found that President Trump violated the Administrative Procedures Act in rescinding DACA. All of this went to the Supreme Court together. The Supreme Court, in a 5-4 decision, ruled that President Trump violated the Federal Administrative Procedures Act when he rescinded DACA. Chief Justice John Roberts wrote for the court. He was joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. I referred to the Administrative Procedures Act. This was a law adopted in the mid-1940s to govern how federal administrative agencies operate. Think of the Social Security Administration, or the Federal Trade Commission, or the Securities and Exchange Commission, or any other federal agency. And it's very detailed. There's a whole course in law school called Administrative Law about the Administrative Procedures Act and what it requires. But one part of it says that an agency decision cannot be arbitrary or capricious. It can't be unreasonable. Chief Justice Roberts, writing for the majority, said that in order to be permissible, there has to be an articulated, legitimate reason for a government's action. If there's not an articulated, legitimate reason, then the agency action is arbitrary and capricious, and it violates the Administrative Procedures Act. If this sounds familiar to you, if I can take you back just a year to June of 2019, you might remember the case, Department of Commerce versus New York. It involved President Trump and the Department of Commerce wanting a question about citizenship on the 2020 census. In the Supreme Court, 5-4, Roberts writing, same just the majority, said there was no articulate, legitimate reason for a question about citizenship on the census. It was just the Attorney General saying he'd do a favor to the Department of Commerce and ask for it. Well, that's what Chief Justice Roberts said here. He said, we just focus on the reasons that were given when the decision was made. And he says, there wasn't any articulate reason because no one talked about the reliance there had been on this by the almost 800,000 dreamers. He said, if the concern was giving them work permits, why not just take that away? Why take away DACA status? Now, what's important is the Supreme Court didn't say the federal government can't repeal DACA. What Chief Justice Roberts says, if the federal government's going to repeal DACA, it has to have an articulated, legitimate reason. It has to consider these major issues, and so sent it back. The good news is, to this moment, President Trump has not rescinded DACA again. The bad news is that the Trump administration is doing many things to circumvent the Supreme Court's ruling without publicly announcing they're doing it. They're not processing new applications for DACA, even though they're supposed to. When there's renewals, they're giving renewals for 1 year, even though it's supposed to be for 2 years. And they're doing many other things to not allow people to continue to have their DACA status. So rather than formally rescind DACA again and go through the hoops prescribed by the Supreme Court, the Trump administration is trying to do it and do it unofficially. So I think you're going to see more lawsuits about this. But at least for now, it's a tremendous victory for the dreamers, for the almost 800,000 people who were brought to the United States as children. As I said, I have students who are dreamers. Some of them were brought to the United States literally as infants. They've never lived in any other country. What would it mean to deport them to a country where they know no one and have never lived? And so my hope is that no matter what happens in the November election, whoever is the president will continue DACA, and if necessary, that Congress will take action to protect the dreamers. The fourth area that I want to talk about concerns religion. And this is the place where the conservatives triumphed last term. In the incredibly kind, overly generous introduction, it mentioned some of my books. Well, I'm going to do a shameless plug, which I hate doing. But yesterday I had a new book that came out. It's called The Religion Clauses, The Case for Separating Church and State. It's with Howard Gillman, published by Oxford University Press, published September 1st. And so I've spent a lot of time in writing this book, looking at what the Supreme Court's doing and likely to do in the area of religion. Now, as you probably know, when you write a book, it goes to press months before it comes out. We turned in the final manuscript for this book last fall. I only wish we could have immediately updated it to include the Supreme Court cases from the end of June. They so bear out the thesis of our book. Our thesis is that the conservatives on the Supreme Court are radically changing the law with regard to the Constitution and religion. For more than a half century, the Supreme Court has had a majority of the justices who believe that there should be a wall that separates church and state. Now, that metaphor of a wall separating church and state doesn't come from liberals of the 21st century. It was Thomas Jefferson in the 18th century who said there should be a wall that separates church and state. In 1947, all 9 justices then on the Supreme Court said that the Establishment Clause should be seen as creating a wall that separates church and state, a wall that's high and impregnable. But the 5 conservative justices on the current court explicitly reject the idea of a wall that separates church and state. For them, the government violates the Establishment Clause only if it coerces religious behavior. So for the conservatives, religious symbols on government property never offend the First Amendment. For them, religious presence in government activities is fine. Government aid to religion, including religious schools, is permissible and even required. Now, with regard to the Free Exercise Clause, in 1990, Justice Antonin Scalia wrote an opinion that says that there's no basis for a religious exception from general laws. This is Justice Scalia, as conservative as anyone who's been on the court in modern times, saying, if it's a general law, you can't claim your religion as a basis for an exception from it. But the conservatives on the Supreme Court are now very much rejecting that and very much want to give exceptions from general laws to those who have religious beliefs. And we saw that in 2 cases from this term that I want to talk about. The first is Espinoza versus Montana Department of Revenue. The state of Montana created a tax credit program where people who gave money to a private school tuition organization could get a tax credit. Virtually all of this money in Montana went to Catholic schools or evangelical Christian schools. Those were the private schools in Montana. The Montana Supreme Court declared this unconstitutional as violating the Montana state constitution. Montana, like many states, has a state constitutional provision that forbids direct or indirect government aid to religion. Montana said that's what this law does. Now, I would think that should have been the end of the litigation. Montana had a law. The Montana Supreme Court struck it down as violating the Montana Constitution. It's not that anyone could say that Montana was discriminating in this law in favor of secular schools and against religious schools. Montana's law didn't exist anymore. It wasn't giving benefits to anyone. But the Supreme Court's majority disagreed with that. In a 5-4 decision, the Supreme Court reversed the Montana Supreme Court. Chief Justice Roberts wrote the opinion for the court, joined by Justices Thomas, Alito, Gorsuch, and Kavanaugh. Here, Justice Kagan wrote a very strong dissent, joined by Justices Ginsburg, Breyer, and Sotomayor. Chief Justice Roberts' majority opinion said, based on a decision from 3 years earlier, that any time the government discriminates against religious institutions, when it's not being given, when they aren't being given benefits that go to secular institutions, the government has to meet a heavy burden and show that its action serves some compelling interest, and it's the only way to achieve it. And he said, the government can't deny religious institutions benefits that it gives to secular institutions. He says that's what the Montana Supreme Court would do. This is a radical change in the law. Now, anytime the government gives benefits to a secular private school, it is constitutionally required to give those benefits to a religious school. Prior to 2017, never once in American history had the Supreme Court said the government was required to give benefits to a religious institution. For decades, the litigation about, well, when did it violate the Establishment Clause for the government to give benefits to religious schools? Now it's the government is required to give benefits to religious schools. The other case that I want to talk about here is also very troubling to me. It's Our Lady of Guadalupe School versus Morrissey Baru. There were actually two cases here. Both involved Catholic schools. Both involved lay teachers at those schools. In one instance, a teacher was fired on the basis of disability. The teacher developed breast cancer, needed to take time off for treatment. And when she came back, she was told her job was gone. She wanted to sue under the Americans with Disabilities Act that would forbid this. It requires reasonable accommodation. This certainly wasn't reasonable accommodation. The other case involved a teacher at a Catholic school who was fired, and he alleges it was to hire somebody younger and cheaper than him, and he sued for age discrimination. The Supreme Court, in a 7-2 decision, held that it violates free exercise of religion, hold a religious school liable for the choices it makes for who its teachers will be. Justice Alito wrote the opinion for the court. Only Justices Ginsburg and Sotomayor and Ginsburg dissented. Justice Alito said, in 2012, the Supreme Court had decided a case, and it was called Hosanna Tabor Evangelical Lutheran School with Equal Employment Opportunity Mission, which involved a 5th grade teacher. Cheryl Perec was a 5th grade teacher at a religious school in Michigan. That school ordained its teachers as ministers. Perec became ill. She took time off work. When she got better, she said to the school, I'm well, I'm ready to teach for you. And they said, sorry, we filled your job, we don't need positions. She sued under the Americans with Disabilities Act. The lower court ruled in her favor, but the Supreme Court ruled against her. The Supreme Court said a religious institution can't be held liable for the choices it makes is to be its ministers. Well, the United States Court of Appeals for the Ninth Circuit, in the cases that I just mentioned to you, said Hosanna Tabor is a limited decision. It's about choices as to ministers. These teachers aren't ministers. There's a dispute over even how much of their responsibilities involve things related to teaching religion. The Supreme Court reversed the Ninth Circuit. What the Supreme Court decision means is that religious schools can act with impunity in refusing to hire, firing teachers based on their race, their sex, their religion, their sexual orientation, their age, their disability. In other words, the Supreme Court has created a broad exception to employment discrimination laws for religious schools for the choices they make as to who will be their teachers. I don't believe the free exercise clause should be a basis for exceptions from general laws. I believe that people should not be able to use their religion to inflict injuries on others like discrimination. But at the very least, I believe that stopping employment discrimination in this area is a compelling government interest. Justice Sotomayor in her dissent lamented that this does let religious schools discriminate with impunity, even when the discrimination has nothing to do with the faith, the doctrines of the religion. The fifth and final area that I want to talk about concerns presidential subpoenas. And two cases came down on July 9th that involved subpoenas of financial records concerning Donald Trump. One of the cases was Trump versus Vance. This involves a grand jury in New York that's investigating alleged campaign finance violations from the 2016 presidential election. You might remember Michael Cohen revealed that over $100,000 was paid to Stormy Daniels to remain silent about her sexual relationship with Donald Trump. This would be a campaign expenditure under the terms of New York law, and the grand jury is investigating it. Subsequently learned that the grand jury is also investigating other allegations of fraud against President Trump and his businesses. The grand jury subpoenaed records from President Trump's accountant, Mazars USA. President Trump went to federal district court to quash the subpoena. The district court ruled against him, the Second Circuit ruled against him, and it went to the Supreme Court. The Supreme Court, in a 7-2 decision, also ruled against President Trump. Once more, Chief Justice Roberts wrote the opinion. Here, Justice Thomas and Alito dissented. Chief Justice Roberts said, "The law has the right to every person's evidence." The court said the president has no immunity from grand jury subpoenas. The court said, anytime somebody believes the grand jury is acting in an abusive way, they can go to quash the subpoena. The president could do that too, but the president doesn't get any special protections from grand jury subpoenas. The case was sent back. The district court level, President Trump moved to quash the subpoena again. The district court denied it. It's on appeal to the Second Circuit, and they're going to have an oral argument in about 2 weeks. The bottom line of this is that President Trump has lost, but it's not going to lead to his tax records coming up by Election Day. The other case is called Trump versus Mazars USA. It was actually two different cases that were consolidated. Both involved congressional committees. One congressional committee subpoenaed President Trump's bank records from his bank, Deutsche Bank, as part of a congressional investigation. The other congressional committee subpoenaed his records from his accountant, Mazars USA. President Trump went to federal courts to quash the subpoenas. The federal courts ruled against him. The courts of appeals ruled against him, but it went to the Supreme Court. Here, the Supreme Court, in a 7-2 decision, took a more middle-of-the-road approach. Again, Chief Justice Roberts wrote for the court. Again, Justice Thomas and Alito dissented. On the one hand, the Supreme Court rejected President Trump's claim that a president can invoke absolute immunity and total protection from his financial records subpoenaed. On the other hand, the court also said that there's separation of powers considerations that need to be taken into account when it's a subpoena for a president's financial records. And Chief Justice Roberts said courts need to look at 4 factors. What's the justification for Congress needing information? Is there any way to achieve it? Is the subpoena as narrowly tailored as possible? How detailed are Congress's reasons for wanting information? The more detailed, the better. And what would be the burden on the president? And the cases were remanded back. These two aren't going to be resolved by November 3rd. So here too, we're not going to get the president's subpoenas. Overall, I think these cases are a victory for the rule of law. To me, the core of the rule of law is that no one, not even the president, is above the law. And the court rejected President Trump's claim of absolute immunity. I think the court could have gone further in upholding Congress's power to subpoena than it did in Trump versus Mazars, but I was at least happy to see the court emphatically rejected some kind of absolute protection for the president, something that's inconsistent, I believe, with our constitutional democracy and inconsistent with the rule of law. So those are the 5 areas I want to talk about. You should feel free to ask me questions about anything else you want from the term or about these cases.
Oh, wow. Thank you. Did we get credit for this course?
If you're a lawyer, we can probably work out to get you MCLE credit.
Yes, I think I saw that. Anyway, thank you so much. We have a few questions, some of which are a little long, and I'm going to have to lean in literally to, let me put my camera back on. There we go. Okay. Dean Chemerinsky, thank you for your presentation. I won't remind you of your predictions from your last time with us, but those were the 5 cases, by the way, in the alphabetical order came back to me. I think you had some surprises, actually, though. But I will ask you a follow-up. How do you expect the Attorney General of New York subpoena of the Trump Organization's financial and tax records to be decided on appeal? And can you comment on the 2nd District's ruling in the last few weeks?
The Southern District of New York has again said that President Trump must comply with the subpoenas. The 2nd Circuit has stayed that pending their hearing the case and deciding it. I don't regard that as an unusual move. All that means is that the subpoenas won't be enforced until the 2nd Circuit can hear the case. As with almost anything, when it comes to a court of appeal, I would want to know who are the judges before I make a prediction as what they're likely to do. When I have a case, say in the 9th Circuit or any circuit, where I hear of a friend who has an argument, I always want to know who's the panel, who are the judges. It makes all the difference in so many cases. I don't know who the judges are on the 2nd Circuit in this case. I think I can remember who they were last time. If it's the same panel, I think that they're likely to affirm the district court.
And that's why they don't announce the judges until right before the case is heard.
Well, in the 9th Circuit, you get to find out your judges a week before. On Monday morning at like 5 a.m., the week before the argument, you can find out your panel. And I've got to tell you, when I have a 9th Circuit argument, I'm up at 5 a.m. the Monday, the week before to find out. In some circuits, like the 4th Circuit, which is in Richmond, Virginia, or the 7th Circuit, which is Chicago, you don't find out your panel to the day of the argument when you arrive at the court.
Okay, here's another question. Thank you. So someone would like to know, could another identical abortion center restriction law, that's a big long verb, noun string, could another identical abortion center restriction law end up before the Supreme Court from another state?
It could. I think if it's identical to the Texas and the Louisiana law, we now know the Supreme Court's going to strike it down. But what about all of the other restrictions on abortion that states have adopted? In their almost infinite, some states prohibit prescribing abortion-inducing medication over the telephone or over Zoom, prohibiting telemedicine. Are those constitutional? I mentioned the ones that want to prohibit abortions after the fetal heart being detected. There are laws that prohibit abortion after the 20th week of pregnancy. Almost anything that you can imagine, and probably much that would never cross anyone's imagination, that might be done to restrict abortion has been done in some of the states. I believe there are 4 votes to uphold all of those restrictions on abortion. I believe there are 4 votes to overrule Roe versus Wade: Thomas, Alito, Gorsuch, and Kavanaugh. I think the question is, how far will Chief Justice Roberts go? Is this an isolated vote to strike down a statute? And I think there's a way that it might be just that. This was the 5th Circuit basically ignoring a Supreme Court decision from 2016. And I think John Roberts is trying to send a message to Court of Appeals: you have to follow Supreme Court decisions. But that then wouldn't predict how Roberts will vote on other abortion issues. Or is this an indication that Roberts is really going to take stare decisis and precedent seriously with regard to abortion? And if that's the case, then the court might be more willing to strike down other laws. But I think on abortion, you got 4 to allow any restriction, including a total prohibition on abortion, 4 to protect abortion rights, and it just depends right now on John Roberts.
Okay, we have a question that was emailed to us earlier in the day,
Yes.
which you saw. Do you expect that the decision in McGirt versus Oklahoma will have an impact behind the area of criminal justice, such as property rights, contract rights, eminent domain, zoning, etc.?
McGirt versus Oklahoma was decided on Thursday, July 9th. It involves a large part of eastern Oklahoma, and it involves individuals who are a part of the Creek Indian tribe. And that's what used to be the territory of the Creek Indian tribe. And under a treaty between the United States and the Creek Nation, those from the Creek tribe committing crimes on tribal land need to be prosecuted in federal court. Imagine somebody in eastern Oklahoma commits a state law crime. Murder, rape are state law crimes. They're not federal crimes generally. Under the terms of the treaty and a federal law that says it's to be enforced, the person would have to be prosecuted in federal court. And the question before the Supreme Court was, who had been convicted in Oklahoma state court, but a member of the tribe and on tribal land, did he have a right to be tried in federal court instead? And the Supreme Court said yes in a 5-4 decision. Justice Gorsuch wrote, joined by Justice Ginsburg, Breyer, Sonora, and Kagan. So the practical immediate significance is in eastern Oklahoma, a member of the Creek tribe committing a state law crime on tribal land must be prosecuted in federal court. But at the very end of his majority opinion, in the last paragraph, Justice Gorsuch in eloquent language said, promises between the United States government and Native American tribes must be kept. There are a lot of promises that have been broken over the years, and some of those promises involve the areas such as property rights, contract rights, eminent domain, and zoning. And just in the not quite 2 months since the Supreme Court decision, lots of activity is happening where tribes are trying to use McGirt beyond the criminal law area in these as well. And we'll see what happens.
Here's a short question. Why is precedent so important? The long answer.
The reason precedent is given weight is to provide stability and predictability in the law. People rely on the law. And if it's constantly changing, then you don't have stability, you don't have predictability, you don't have the ability to rely on the law. Think about let's take affirmative action as an instance. The Supreme Court has been clear about what college and universities can do with regard to affirmative action. Imagine college and universities do exactly that. But then the Supreme Court says, nah, we don't pay any attention to precedent. We're going to overrule that. Or lower courts rely on precedent. Well, if it's always changing, then how can lower courts do their job? And so the Supreme Court, lower courts have all said that to give stability and predictability to the law, they'll follow precedent. But precedent is never absolute. Everyone agrees that it was essential that Brown versus Board of Education overruled Plessy versus Ferguson. But precedent also matters. And so it's a question of how much weight should be given to precedent. And I think most were surprised that Chief Justice Roberts struck down the Louisiana law, emphasizing precedent in stare decisis.
Okay, looks like we have one last one here. Could you explain the pardoning privilege of presidents? Are there any restrictions? Can individuals be prosecuted in any fashion after such a pardon?
The president can pardon anyone accused or convicted of a federal crime. I want to emphasize, anyone accused or convicted of a federal crime. You might remember Gerald Ford issued a pardon to Richard Nixon, even though Nixon had never been convicted of any crime, and that's permissible to do. The pardon power is just that, the ability to pardon anyone accused or convicted of federal crime. Is there any exception? Yes, the Constitution mentions one exception. A person who's been impeached by the United States House of Representatives can never be pardoned for the crimes that led to the impeachment. So Bill Clinton was impeached by the House. He can never be pardoned for the crimes that led to the impeachment. Had Richard Nixon been impeached by the House, and it never got that far. Gerald Ford couldn't have pardoned him for those crimes. But that's the only exception that's mentioned in the Constitution. There's an interesting question many have asked. Can a president pardon himself? Many are asking, well, could Donald Trump give a blanket pardon to himself on January 19th before he leaves office? No one knows the answer to that question because no president has ever tried to do so. Now, I think a more plausible scenario is if Trump loses on January 20th, at 11:45, he'll resign, make Mike Pence president for 15 minutes, and Pence then can pardon Donald Trump. There's nothing that anybody can do about it. Can individuals be prosecuted in any fashion after such pardons? A person can be pardoned by the president for federal crimes. A person can't be pardoned by the president for state law crimes. So, if a person is pardoned, imagine hypothetically that Michael Flynn gets pardoned by the president. Michael Flynn can't be prosecuted in federal court for those crimes again. But it doesn't stop a state from being able to prosecute Michael Flynn for those crimes. A president can't pardon as the state criminal liability, and double jeopardy doesn't preclude being able to prosecute in state court, even if you've been prosecuted in federal court, even if you've been pardoned. And this could be quite important in the future. A pardon does not preclude a state government, if it chooses, from pardoning individuals.
Okay, we've got a few more that just popped
Sure.
up. How could the Supreme Court become involved in deciding the 2020 election? Oh, wow.
In countless ways. We've already seen the Supreme Court play a role with regard to the primary election season. I didn't talk about it, but there was a case on April 6th, Republican National Committee versus Democratic National Committee. The Wisconsin primary was going to be on April 7th. An unusually large number of people, for obvious reasons, requested absentee ballots. The post office hadn't been able to process them. People hadn't received them. They hadn't been able to turn them back in. So a federal judge in Wisconsin said to protect the right to vote, rather than the ballots having been received by April 7th, we'll say they just have to be received by Monday, April 13th. The Supreme Court 5-4 reversed and said the federal district court couldn't do that. They said the federal courts can't change the rules of the election soon before the election. There's going to be lots of issues coming up with regard to absentee ballots, hours of polling places, location of polling places. And I worry that the court's not going to allow the federal judiciary to take the actions necessary to protect the right to vote. After the election, how might the court be involved? Just remember Bush versus Gore from 2000. I'm teaching a seminar this semester for first-year law students on civil liberties in a pandemic. And we were talking about the election-related cases. And I was talking about Bush versus Gore. And I realized that none of my students remembered it. And I said, do you remember, for example, the butterfly ballot? And not one of the students in my seminar remembered the butterfly ballot from Bush versus Gore. And so I sort of did a history lesson for them. But, that was 20 years ago. And, students, first-year law students, I don't know, many of them are 22, 23, 24, 25 years old.
Okay, there's one last one. What happens if a justice is ill or incapacitated during the next term?
If a justice becomes ill or incapacitated, he or she remains a justice until he or she resigns from the bench. So imagine Justice X becomes ill and just can't participate. We'll just go with 8 justices. The justice is still a justice until he or she dies, retires, or is impeached and removed. There was one term where William Douglas was ill and missed the entire term, didn't participate in any oral arguments, any decisions. In his last year on the term, 2004-2005, William Rehnquist was dealing with thyroid cancer, and he missed a number of the arguments, and he didn't participate in some of the cases. Some he participated in, even though he wasn't on the bench for oral argument by listening to the tapes. But if a judge is ill or incapacitated, If the justice resigns because of it, the president can pick a successor. But if the justice doesn't resign, the court just functions with 8 justices.
Okay, well, I think that's it for the questions for this term. And I can't thank you enough. I'm sure everyone who's still with us joins me in expressing our gratitude, and we hope that we'll see you again
My pleasure.
next term.
My pleasure, and I hope we'll get to do it in person, but if not, by Zoom.
Yes, we would all like to do it in person and have you at the City Club for dinner again.
I'd like that very much, but if not, delighted to do it this way.
Okay, stay well, and thank you again.
You too. Thank you.